On the very last day of its term, June 30th, 2026, the Supreme Court did something it had specifically avoided doing for years. It agreed to decide, directly and finally, whether the Constitution protects your right to own an AR-15. Not a narrow procedural question, not a side issue about permits or storage. The actual central question that roughly a dozen states have been legislating around for over a decade without ever getting a definitive answer from the nation's highest court. If you live in a state with an assault weapons ban, or you are watching one work its way through your own state's legislature right now, this is the case that is going to settle the question everyone else has been arguing about for years, and it just landed on the court's docket for real, with a decision now expected within the next 12 months, rather than remaining an open, indefinitely deferred question the way it has been for most of the last decade. Quick thing before we get into it. I track Supreme Court cases the moment they are granted, not just the moment they are decided, because knowing a case is coming, and what it could mean for your state specifically, matters just as much as knowing how it eventually turns out. If that is useful, subscribe and turn on the bell, because this case is going to develop in stages over the next year, and I will be covering every one of them. 2 seconds, and let's get into what actually happened. The Supreme Court granted certiorari in 2 cases at once, consolidating them for a single hour of oral argument on a single shared question. The first is Viramontes versus Cook County out of Illinois. The second is Grant versus Higgins out of Connecticut. Both challenge state or local bans on a category of firearms generally described as assault weapons, and the court consolidated them specifically to decide one question that applies to both: whether the Second and 14th Amendments protect the right to possess AR-15 platform rifles and similar semi-automatic firearms that are, in the language courts use, in common use for lawful purposes. Consolidating 2 separate cases for a single argument is itself a meaningful signal. It tells you the court views these 2 disputes as presenting fundamentally the same legal question, rather than 2 distinct issues that happen to involve similar facts, which means the eventual ruling will almost certainly be written broadly enough to resolve both cases together, rather than narrowly enough to apply only to one specific state's particular statutory language. Let's start with where each case actually came from, because the specific facts matter for understanding what the court is going to be looking at. Cook County, Illinois enacted its ban back in 1993, prohibiting the sale, transfer, and possession of a defined list of assault weapons, including AR-15S, AK-47S, and roughly 125 other specifically named rifle models, along with magazines holding more than 10 rounds, making it one of the older assault weapons bans still on the books anywhere in the country. That county-level ban became the direct template for Illinois' own statewide ban passed years later, which means this case, even though it is formally about Cook County specifically, has implications reaching well beyond that one county and directly touches the newer statewide law modeled on it. Cuthberto Viramontes wants to purchase an AR-15 for self-defense and legally cannot do so under this ban. Joined by fellow plaintiff Christopher Kaya, along with the Firearms Policy Coalition and the Second Amendment Foundation, he sued in federal court back in August of 2021, meaning this specific case has already been working its way through the legal system for nearly 5 years before finally reaching the point of Supreme Court review. A district court granted summary judgment in favor of Cook County in 2024, and the Seventh Circuit Court of Appeals upheld that ruling in 2025, meaning Viramontes lost at every stage before reaching the Supreme Court, a losing streak that makes the eventual cert grant itself notable, since the court does not have to take a case simply because a losing plaintiff asks it to. Grant versus Higgins comes out of a very different, though related, legislative history. Connecticut's ban dates to the aftermath of the 2012 Sandy Hook Elementary School shooting, and it prohibits possession of semi-automatic rifles, including the AR-15, acquired after April 3, 2013, both by specific name and by a broader feature-based definition similar to the kind of definition you have probably seen in other states' laws, including Virginia's. Violating it is a felony under Connecticut law. The plaintiffs, backed by the Second Amendment Foundation and the Connecticut Citizens Defense League, challenged the ban, and the Second Circuit Court of Appeals upheld it as well, following what SAF's own public statement described as a troubling and, in their view, misguided preliminary injunction ruling along the way, a characterization that gives you a sense of how contentious even the procedural steps in this litigation have been, well before the case ever reached Washington. So, why did the Supreme Court agree to hear these 2 specific cases now, after both circuit courts ruled against the challengers, when the court has repeatedly passed on similar opportunities in years past. This is genuinely one of the more interesting parts of the story. In 2025, the court denied certiorari in a similar case called Snope v. Brown, challenging Maryland's assault weapons ban, and at the time, Justice Brett Kavanaugh wrote separately to signal that the court should, and in his own words presumably would, address the AR-15 question soon, in the next term or two. That is exactly what happened, almost precisely on the timeline he predicted, and his willingness to write publicly about the court's likely future direction on a question it had just declined to answer was itself an unusual and closely watched signal at the time, one that gun rights advocates and gun control advocates alike had been watching for ever since. It is also worth knowing that the Viramontes petition specifically was distributed for the court's private conference 22 times since last November before the justices finally agreed to grant it, an unusually long deliberation process that suggests this was a genuinely difficult, closely debated decision about whether and when to take up this question, not a snap decision made lightly, and 22 distributions without a grant or denial is a strong signal that at least some justices were actively working behind the scenes on exactly how to frame the question the court would eventually agree to answer. Here is what actually happens next, and the timeline matters if you are trying to figure out how urgently this affects your own situation. Oral argument has not been scheduled yet, but it is expected sometime in the fall of 2026, early in the court's next term, which formally begins the first Monday in October. A decision is expected by June of 2027, following the court's typical pattern of deciding argued cases before its term wraps up for the summer, though the court has occasionally taken until the very last days of a term to release its most consequential and closely contested rulings, meaning a decision on a case this significant could plausibly land anywhere from late in 2026 through the final week of June 2027. That means this is not an immediate this week kind of story. It is closer to a year-long story, unfolding in stages. Argument first, then a wait of several months, then a final ruling that will directly determine the constitutionality of assault weapons bans nationwide, and each of those stages is worth its own attention rather than treating this as a single event that already happened on June 30th. Now, let's talk about who this actually affects, because the scope here is genuinely large. Assault weapons bans similar in structure to Cook County's and Connecticut's currently exist in roughly a dozen states, including California, Connecticut, Illinois, Maryland, Massachusetts, New Jersey, and New York, among others, covering a meaningful share of the country's total population, even though it is a minority of states by count. If you have been following gun law developments closely, you may recognize some of these names from other recent stories, and that is not a coincidence. Virginia's own newly signed assault weapons ban, Senate Bill 749, is currently the subject of a separate federal lawsuit called McDonald v. Katz, filed specifically because its own plaintiff's attorneys openly expected to lose at the lower federal court level due to existing Fourth Circuit precedent, and were building a record aimed at eventually reaching the Supreme Court on this exact question. Now, the Supreme Court has agreed to take up that exact question anyway, through a completely different pair of cases entirely, which means every state currently defending a similar ban and every plaintiff currently challenging one now has a single nationwide answer coming that will likely resolve most or all of these separate fights at once, rather than requiring each state's litigation to work its way up independently over the following several years. That includes not just Virginia's brand new law, but Maryland's own long-running litigation, which produced the Fourth Circuit precedent, Bianchi v. Brown and Colby v. Hogan, that has been blocking similar challenges throughout that circuit, precedent that a ruling in Viramontes could either reinforce or completely override depending on which way the Supreme Court ultimately goes. If you live in one of these states, here is what you should actually understand about your situation right now. Nothing has changed yet, today, in terms of what is legally enforceable where you live. A cert grant means the Supreme Court has agreed to hear a case. It is not itself a ruling, and the underlying state and local bans remain fully in effect and enforceable while this litigation proceeds. What has changed is the level of legal uncertainty hanging over all of these laws simultaneously, since a ruling either way, striking these bans down as unconstitutional or upholding them, will likely apply well beyond just Illinois and Connecticut, given that the underlying constitutional question is the same one nearly every other assault weapons ban in the country ultimately rests on. The core legal question the court will actually be answering traces back to a specific test the court itself created in its landmark 2008 ruling in District of Columbia versus Heller, which held that weapons in common use by law-abiding citizens for lawful purposes are constitutionally protected, while weapons that are dangerous and unusual are not. That single sentence from an 18-year-old ruling is the entire battlefield this case will be fought on. Both sides in this case are going to be fighting almost entirely over which category the AR-15 platform actually falls into. Gun rights advocates point to the sheer number of AR-15 style rifles legally owned in the United States, commonly cited in the tens of millions, as clear evidence they are in common use by any reasonable definition, and argue that a weapon owned by that many law-abiding citizens for lawful purposes cannot simultaneously be dangerous and unusual in the constitutional sense, since unusual by definition implies rarity, not mass ownership. States defending their bans argue that a weapon's raw popularity does not automatically make it constitutionally protected, particularly when that same weapon has been used disproportionately in mass shooting incidents relative to its role in ordinary self-defense situations, and that the common use test was never meant to immunize a weapon from regulation simply because manufacturers successfully sold large numbers of it before a ban took effect. This is not a new argument. Both sides have been making versions of it in lower courts for years, generating genuinely inconsistent results across different circuits, even while the Seventh and Second Circuits both ultimately sided with the states in these two specific cases. But this will be the first time the Supreme Court itself weighs in directly and definitively on which side of that specific line the AR-15 falls, rather than leaving the question to be argued and re-argued differently in every circuit that happens to hear a similar case. This case also sits downstream of the historical tradition test the court established in 2022's Bruin decision and refined further in 2024's Rahimi ruling. Under that framework, it is not enough for a state to argue a ban serves a good public safety purpose. The state has to point to an actual historical tradition of regulating comparably dangerous weapons at the time the Second Amendment, or the 14th Amendment, was adopted. States defending assault weapons bans will need to argue that historical restrictions on weapons considered unusually dangerous for their era, cannons, certain edged weapons, and similar historical outliers establish a broad enough principle to justify modern restrictions on the AR-15 specifically. Gun rights advocates will argue that no meaningful historical analog exists for banning an entire, extremely popular class of firearm based on features rather than genuine danger, and that the historical record actually cuts against the kind of sweeping, category-wide bans currently on the books in a dozen states. So, what should you actually do with this information right now, today, if you live in an affected state? First, understand clearly that no state or local assault weapons ban has been struck down or altered by this cert grant alone. Every one of these laws remains fully enforceable exactly as it was the day before June 30th. Second, if you are considering a firearm purchase, a legal challenge, or any decision that depends on how this area of law might change, understand that meaningful clarity is roughly a year away at the earliest oral argument in the fall, a ruling by next June, and treat any decision you make in the meantime as being made under the current law as it exists today, not the law as it might exist after this case is decided. Third, keep watching for the oral argument date once it is scheduled, because the specific questions the justices ask during argument often give a meaningful preview of where the eventual ruling is headed, the way Chief Justice Roberts' questioning did in the recent Wolford versus Lopez case. Let me clear up a few claims already circulating about what this cert grant means, because it is early enough in this story that misinformation has a real chance to spread before any ruling actually exists to correct it against. The first claim is that the Supreme Court has already ruled AR-15 bans unconstitutional. That is false. The court has only agreed to hear the case. No ruling exists yet, and predicting the outcome based on which justices granted cert is genuinely unreliable, since justices sometimes vote to grant cert on a case precisely because they want to affirm the lower court's ruling, not just to reverse it. The second claim is that this ruling, whenever it comes, will only affect Illinois and Connecticut. That is also false, because the court is deciding the underlying constitutional question generally, not just whether these two specific laws happen to be valid, meaning the ruling's reasoning will almost certainly extend to every other state's comparable ban, even though each individual state's specific law may still require its own follow-up litigation to formally strike it down or confirm it survives. The third claim is that gun owners in Illinois or Connecticut should stop following current law in anticipation of a favorable ruling. That is not just false, it is actively dangerous legal advice. Current law remains fully in effect and fully enforceable until and unless the Supreme Court says otherwise, and anyone acting as though the law has already changed based on a cert grant alone is taking on real legal risk based on a misunderstanding of what a cert grant actually is. Let's also walk through what a ruling either direction would actually mean in practice, because both outcomes carry real, significant consequences depending on which way the court goes. If the court rules that the Second Amendment protects AR-15 style rifles as weapons in common use, every assault weapons ban in the roughly dozen states that currently have one would likely become unenforceable, or at minimum face an extremely difficult path to surviving further litigation, representing the single largest expansion of gun rights since Heller itself was decided in 2008. States would likely need to pivot toward other regulatory approaches entirely: magazine capacity limits, purchase age requirements, storage rules, rather than category-wide bans on the rifle platform itself. If the court instead rules that these bans are constitutional, it would provide the first direct Supreme Court validation of assault weapons restrictions as a category, likely encouraging additional states to pass similar bans with considerably more legal confidence than they currently have, and potentially reshaping how lower courts evaluate feature-based firearm restrictions across the country for years to come. Either outcome would be the most consequential Second Amendment ruling since Bruin itself, which is exactly why this case has drawn this much attention less than 3 weeks after cert was even granted. Step back and look at what this cert grant actually represents in the bigger picture of Second Amendment litigation. For years, the Supreme Court has been willing to nibble around the edges of gun rights questions, permitting standards, sensitive places, private property defaults, while consistently declining to take up the single biggest, most consequential question hanging over the entire area of law: whether the most commonly purchased rifle in America is itself constitutionally protected. That avoidance is over. Whatever the court ultimately decides, sometime before next summer, this will be the most significant Second Amendment ruling since the historical tradition test itself was established back in 2022. And it is very likely to determine the fate of every assault weapons ban currently on the books in this country, not just the two specific laws formally named in these two consolidated cases. Every piece of litigation currently working through lower courts on this exact question, Virginia's McDonald versus Katz, Maryland's ongoing fight, and any other state's pending challenge, is now effectively paused in significance, waiting on an answer that is about to come from the only court whose answer actually settles the question nationwide, rather than circuit by circuit. If this helped you understand what just happened and why it matters even though nothing has technically changed yet, hit like so it reaches other people in affected states who need to understand the actual timeline here, rather than panicking or celebrating prematurely, and subscribe if you have not, because I will be covering the oral argument the moment a date is set, and the ruling itself the moment it comes down next year. This is genuinely a story that will unfold in distinct, spaced-out chapters rather than all at once. The oral argument itself will be worth a dedicated breakdown when it happens, since the specific questions asked often preview the outcome, and the eventual ruling will likely be long, detailed, and worth walking through section by section, given how much is riding on it for a dozen states simultaneously. Tell me, in the comments, which states ban you are personally watching this case affect, because that tells me exactly which state-specific angle to prioritize as this story develops over the coming months, whether that is Illinois, Connecticut, Maryland, Virginia, or somewhere else entirely.